County of Los Angeles, Department 534 is now in session. The Honorable Judge Ron Rose presiding. Please be seated and come to order. At this time, I will review the courtroom rules. During the trial, all cell phones must be silenced or turned off. If you have not done so already, please take the opportunity to do so now. During the trial, there will be no talking in the audience. In addition, no food or beverages are allowed in the courtroom, with the exception of water. Thank you for your cooperation.
Welcome to the final round of the mock trial competition. I offer my congratulations to both teams for making it here tonight. I am Ron Rose. I'm the judge of the Superior Court. I sit in a criminal court a couple of blocks from here. And we have a very esteemed group of scorers here tonight. And I'm going to ask each of them to stand and please identify yourself for the students.
I'm Barry Edwards.
Good evening, ladies and gentlemen. My name is Sharon Matsumoto. I am the Chief Deputy of the Los Angeles County District Attorney's Office. It's been my privilege to be part of the mock trial program for more than 25 years. On this very auspicious occasion, I wish both teams good luck and have a great time.
Good evening. My name is Kelly Emling. I'm the Chief Deputy in the Public Defender's Office, and I've had the honor of working with both our judge and the Chief Deputy in the District Attorney's Office, and I wish you all good luck and have a wonderful evening.
Starting with our prosecution team, would you please stand to identify yourselves?
Good afternoon, Your Honor. My name is Alan Michelle. I will be representing the people in this matter. I will be delivering the opening statement, direct examining Detective Reese Barron, as well as cross-examining Cindy Ogden and T.M.
Good afternoon, Your Honor. My name is Enya Huang, and I represent the people in this matter. Today, I will be delivering the direct examinations of Bernie Worcester and Marty McCullough, and the cross-examination of Jamie Sardania.
Good afternoon, Your Honor. My name is Grant Paycheck. I'm representing the people in this matter. Today, I will be delivering the cross-examination of the defendant, Evan Shem, the direct examination of Charlie Gibbons, and the closing argument.
Good evening, Your Honor. My name is Nadia Rahman, representing the people in this matter. Today, I will deliver the prosecution pre-trial motion. At this time, may our witnesses now introduce themselves?
Yes, please.
Good evening, Your Honor. My name is Megan Cohen, and I am Detective Reese Barron.
Good evening, Your Honor. My name is Alex Paycheck, and I am Charlie Gibbons.
Good evening, Your Honor. My name is Nadia Rahman, and I am Bernie Worcester.
Good evening, Your Honor. My name is Sebastian Grande, and I am Professor Marty McCullough. At this time, may our court clerk introduce himself.
Yes.
Good evening, Your Honor. My name is Timothy Salton. Today I'll be your clerk. At this time, may our lawyer coaches and teacher coach introduce themselves?
Yes, please.
Good evening, Your Honor. I'm David Waterhouse, teacher advisor.
Good evening, Your Honor. My name is Barbara Kunatz, and I'm an attorney coach.
Good evening, Your Honor. I'm Alan Kroll, and I am a lawyer coach.
Thank you.
Thank you, Your Honor.
The defense team, please.
Good evening, Your Honor. My name is Catherine Lynn, and in tonight's trial, my co-counsel and I will be representing the defendant, Evan Shem. I will be conducting the direct examinations of expert Jamie Sardania and defendant Evan Shem. I will also be conducting the cross-examination of Detective Reese Barron.
Good evening, Your Honor. My name is Gopika Jalan, and today I will be conducting the direct examination of Cindy Ogden, the cross-examination of Marty McCullough and Bernie Worcester, and I will also be delivering the opening statement.
Good evening, Your Honor. My name is Ian Axberg, and tonight I will be conducting a direct examination of T.M. Little, as well as a cross-examination of Charlie Gibbons. In addition, at the end of the trial, I will be delivering the closing arguments. At this time, our pretrial attorney would like to introduce himself.
Yes.
Good evening, Your Honor. My name is James Gale, and tonight I'll be presenting the pretrial argument on behalf of the defense. At this time, our witnesses would like to introduce themselves.
Yes, please.
Good evening, Your Honor. My name is Catherine Petz, and tonight I am Jamie Sardania.
Good evening, Your Honor. My name is Jackie Perez, and tonight I am Tim Little.
Good evening, Your Honor. My name is Kimberly Stover, and tonight I am Sydney Ogden.
Good evening, Your Honor. My name is Carlo Pius, and tonight I am Evan Shem. At this time, our bailiff would like to introduce himself.
Good evening, Your Honor. My name is Arun Gattu, and tonight I will be your bailiff. At this time, our unofficial timer would like to introduce himself.
Good evening,
Judge Rose. My name is Judy Dar. I'm a volunteer attorney coach for tonight's team.
Good evening, Your Honor. Albro Lundy, also a volunteer attorney.
Thank you very much. I assume that both sides understand all the rules of court, and you wait for the reading of the rules and any stipulations. Is that yes?
Yes, Your Honor.
And are we ready to start on the matter of People versus Shem?
Your Honor.
Is the defense ready?
Yes, Your Honor.
And there's a pretrial motion, so we'll start with the defense.
Yes, Your Honor.
And our score has the time cards, and he will be holding it up and also announcing out loud the time remaining.
May I begin, Your Honor?
Yes.
May it please the Court. Since the dawn of our nation, the Fourth Amendment is a critical part of our justice system and our nation's freedoms overall. It provides for the right of people to be secure in their persons, houses, and effects against unreasonable search and seizures. In today's case, Officer Reese Barron's warrantless search of my client's storage locker is constitutionally invalid, and the evidence obtained by the search should be excluded. The following reasons. First, the person whom the detective believed to obtain consent, Charlie Gibbons, was not an occupant, and thus had no authority to consent to a search of premises. Second, even if the court finds that Gibbons did have authority to consent, his consent was not known as required by law. Third, Detective Barron's failure to inquire as to Charlie Gibbons' status as a tenant is not in good faith, thus rendering the search unlawful. For these reasons of lack of authority, lack of known consent, and lack of good faith investigation, we move the court to suppress the evidence found in my client's storage locker. With regard to the matter of consent, we review the court the seminal case of Stoner versus California. In this case, the court found that the hotel clerk had no right to consent to a search of the defendant's room, even though she held access, thus establishing that access does not give authority to consent to search of another space. Although Charlie Gibbons
In that case, did the police believe they had the authority from the consent?
Yes, they did. They conducted a search in the court deemed the search was not permissible.
And why not?
Because although the clerk in that case held access, she had access to the hotel she desired, she was not renting that room that day. Neither was she the owner of the hotel. Thus, she did not have the authority to consent.
I'm a little confused because subjectively, the officer believed that they had a permission to search, correct?
Yes, sir.
So why was the evidence suppressed in that case?
Well, this was the seminal case, so it set the balance. The court said that you either have to be the occupant of that room or the legal leaseholder of the whole hotel in this case to provide valid consent to a search. If she was simply an employee of the hotel, she could not provide valid consent. She wasn't informed of the situation and thus could not be decided that.
And you may continue.
Although Charlie Gibbons may have been familiar with the apartment and had some limited access to public areas, he was neither an owner nor an occupant and thus had no authority to consent. Detective Barrett had a responsibility to establish the situation surrounding occupancy in this case. If he had simply asked Charlie Gibbons, "Are you a resident?" a simple five-second question would have learned that he was not an occupant and thus had no authority to consent to a search.
Is there any case that simply comes out and says the officer must ask that out loud in every case?
It's not so much a question of mapping, it's more of a question of explicit intent, or later of explicit consent. You'll see in Illinois versus Rodriguez and a variety of other cases that explicit consent is really the cornerstone of consent. It's the explicit acknowledgement of ownership or occupancy, and that's really become the foundation for consent.
Are there any cases in which a court has held that implicit consent is sufficient?
No, Your Honor.
Well,
implicit consent would be an objectively reasonable basis. There's not a single case in which implicit consent has been deemed acceptable.
You may continue.
Even if the court finds that Gibbons does have authority to consent, this consent was not known as required by law. When asked by Detective Barrett to search the apartment, Gibbons responded, "The key is in the kitchen." In his own witness statement, Gibbons clearly articulates that by the statement, he fully intended and expected the detective to see actual consent from the owner of the apartment, who sat waiting in the same room as the key. It was simply not objectively reasonable for him to seek consent from an individual who he had never actually seen inside the apartment.
2 minutes.
In U.S. v. Mallow, another case dealing with consent by someone other than the defendant, the court upheld the search after two individual tiers were met. One, the consenter had joint access to the residence, and two, individual control of the area to be searched. Neither of those elements are present in today's case. Charlie Gibbons, as a previous tenant who in fact been evicted, lacked access to or control
Was that known by the officers?
It was not known that he had been evicted. In fact, they weren't sure of his occupancy status at all. Like I said earlier, it's that simple 5-second question you ask. Of course, in an investigation, it's really essentially to understand who's living in the apartment he's trying to search.
And what facts did the officer have for him to surmise that Mr. Gibbons was, in fact, an occupant of the premise?
There were a variety of circumstances that led to his conclusion. A few things related to the apartment and seeing Gibbons there. But with that being said, this case didn't simply occur over 2 days. This case wasn't simply a first impression. It wasn't his first time assessing the situation. He had been there the day before. He had spoken with the defendant already, and thus there was a much higher threshold for which he had to establish. That's what you see in other martial opinions as well.
What about the fact that he had seen the same person as Mr. Gibbons at the location a day before? Taking out trash, doesn't that somehow play into all of this?
Admittedly, it is a factor that might encourage him leaning towards that decision. But again, because he's spoken to him on 2 separate occasions, it only raised the threshold from requiring that explicit consent. Cornerstone, as we've seen, that is essentially established.
What if he has seen him there 3 times, or 4 times, or 5 times? Is there a certain point at which you would agree that the officer had sufficient cause to believe that he was able to consent to the search?
I think that might be more if he had been seen inside the apartment, theaters, perhaps, been in the kitchen, cooking something. Even if he had lounged on the couch watching TV, that would have been a much more explicit sign of residency. However, because the officer only sees him in public areas, I simply can't agree with that.
You may continue.
A third argument focuses on the good faith belief that Charlie Gibbons had the authority to consent. Several cases deal with this mistaken, but objectively reasonable basis on which the individual, not in possession of active authority, to consent to the search. The Illinois v. Rodriguez really leads police to arrest him to describe as our apartment and opens the door with a key from within her own possession. The court later finds that she holds neither access nor authority over this apartment. However, the search is still valid because of the aforementioned objectively reasonable basis. There are 3 key differences between Illinois v. Rodriguez and the case we see before the court today. First, Charlie Gibbons never articulated his joint offer.
1 minute.
Which really, we've seen, is the essential component of ownership. Second, Charlie Gibbons never held the access, in this case, a literal key in his own possession. Third, Detective Barron's failure to, like I said, it was not their first time assessing the occupancy situation. Because of that second day, because he'd already spoken to Evan Shem, who only authorized to occupy the premises, there's a much higher threshold for which he can be satisfied.
Is there really much difference between someone saying, I have a key in my hand, or the key is over there?
I do believe because the key was inside the interior of the apartment because he wasn't there, if I were to pull out a key ring out of the pocket, it's quite clear to you that those keys were in my possession. It was mine, I have the responsibility. I think we've seen time and time again that keys really are an indication of ownership to a car, to a vehicle, to a car, to a house, whatever it may be. So indicating it's in a different place, one that he knows is controlled by the defendant, is definitely separation.
But why would that go to the standard of the objectivity standard that is applied to the officers?
Well, we've seen the 2 tiers of access and authority. And so in this case, that key is the access. If he had had the key ring in his pocket, it would have quite clearly demonstrated he had the accessibility to enter the apartment at any time he desired. Because he was not an occupant, he was not in possession of that access.
So if he had the key in his pocket instead of having it in the home, then you would concede that it was a valid search?
I believe that he would not have had a key in his pocket unless he was an occupant. And in that case, there would be much more valid search. However, I'm not entirely sure on that. I think you would have to go with the higher threshold again.
You may continue.
So with that respect to the report, find Officer Barron's invasion of my client's sword space.
30 seconds.
And exclude any information. Thank you.
Thank you. Ms. Vaughn?
Yes, Your Honor. May I proceed?
Yes.
Your Honor, the search and seizure that Detective Barron carried out on July 7th was lawful and constitutional. I argue this for several reasons. First, Your Honor, as in Florida v. Jimenez, it was objectively reasonable for Detective Barron to conclude that Shem's consent included the car storage shed. Detective Barron was openly searching for Gibbons did consent to a search of the car's storage shed. When Detective Barron asked him, "Can I search this car's storage shed?" he responded with the exact location of the key necessary to make the search. And objectively
Did he ever say yes?
Your Honor, he did not say yes, but an objectively reasonable person would interpret his giving Barron the means to search the cabinet as consent. It is an objectively reasonable conclusion to draw from this.
Why shouldn't we ask the officers to simply ask the question?
Your Honor,
May I search the location?
Your Honor,
It seems pretty simple.
the officer did ask the question, and she received a positive response. She received the information necessary to make the search. Contextually, giving Barron the means to search the cabinet was consent.
Now, if we had a rule that the officers are required to ask, are you consented? That would be very clear, and we wouldn't be in court today, would we?
We would not, Your Honor, but we do not have a rule like that.
So why shouldn't we have a rule?
Your Honor, we should not have this rule because it would be impeding on the officer's right to make warrantless searches. Warrantless searches are an important part of all cases. They give defendants the opportunity to object or consent. And this is what Officer Barron did with Charlie Gibbons. And Charlie Gibbons, an objectively reasonable person would find, did consent to this search.
You may continue.
Thank you. Matlock versus U.S. stated that joint property could be consented to by co-occupants. Illinois versus Rodriguez stated that if an officer had a reasonable belief that someone was a co-occupant and therefore had authority over a piece of property, then they could act on that authority in good faith despite the actual legal status of the consenting party. This means that even if Gibbons was not Shem's legal roommate, Detective Barron still met the requirements for a constitutional search as defined in Soda versus California and Rodriguez. Detective Barron's beliefs that Gibbons lived in apartment B were reasonable because she visited apartment B twice and found Gibbons there both times. The first time, Gibbons was taking the trash out of apartment B, an act that firmly established him in the apartment with the knowledge of the building.
So let me get this straight. If the police come to my home, see someone taking out my trash, and they're parked in my driveway, the police come back the next day, see that same vehicle parked in the driveway, and ask that person, is there a key to open up the front door to the house? Is that enough for the police to believe that person is an occupant and has the ability to consent to the search?
Your Honor, it would depend on a viewing of all of the police's interactions with that person. And
Is there more than what I just said in the interaction between the police
There is, Your
and
Honor.
Gibbons?
There is, Your Honor.
And what is that?
When asked, Gibbons was able to give Detective Barron a detailed account of daily life in apartment B. Account so detailed that a passing friend or guest would not be able to give that account.
What details are those?
He was able to testify to Shem's daily habits, Shem's painting habits, to where Shem stored his paintings.
But did that happen before the search or after the search?
This happened before the search, Your Honor. It happened on July 6th, the day first.
So, under that scenario that I gave you, would the police be able to search the premise?
Your Honor, I believe that the police would be able to search the premises in that account.
Now, what if I told you that was my gardener, who is taking out my trash, who is simply parking in my driveway on 2 consecutive days, and who happens to know my habits?
I would say, Your Honor, that as long as the police did not know that this was your gardener before they made the search, and as long as the police objectively, reasonably believed that this person was an occupant of your house, then their search would be reasonable.
Continue.
Thank you. The second time Detective Barron visited apartment B, she found Gibbons parked in apartment B's spot, again implying that he lived there. And finally, when Detective Barron asked if she could search the car's storage shed, Gibbons responded not with a "I don't live here" or "ask Shem," as a guest or friend would be expected to, but with the exact location
simply submitting to the authority of the police when he pointed out where the key was
Your Honor, there is not.
and not consenting?
I do not believe there is, Your Honor. Gibbons had the chance to either object or consent to the search. In fact, he had the opportunity to say, Detective Barron, I don't live here. Ask him. There was absolutely no pressure on Gibbons, and he should not have felt any pressure.
So the police knew about this situation sometime before they went out to the home, correct?
Knew about what situation, Your Honor?
The fact that Shem is a suspect in this case.
Yes, Your Honor. They did find Shem suspect.
Explain to me why we should not require them to get a search warrant or simply obtain a more explicit consent from Shem and from Gibbons.
Your Honor, it is the police's right to ask people if they can perform a warrantless search. They did not at the time find evidence against Shem so compelling to have to merit a warrant before they had even spoken with Shem. And that we didn't get a warrant, and my explanation for this, Your Honor, is that the police had the right to ask Shem for performing a warrantless search. It is a common police practice. We should not try to inhibit that, and it is a valuable tool for the police.
You may continue.
Thank you. For these reasons, Your Honor, we respectfully ask that you rule in favor of the prosecution in this pretrial motion and admit the evidence into court. Thank you.
Thank you. Would you like to respond to that?
Yes, Your Honor. May I begin, Your Honor?
Yes.
The cases cited against the property in this case is Florida v. Meadow and People v. Shem. In both of these cases, the actual evidence lies within the perimeter. In People v. Shem, it's related to a hotel room, and the hotel room bathroom is the subject of question. In Florida v. Meadow, it's a small paper bag within the interior of the car. Both of these cases are drastically different in this case. In this case, there's an apartment and an entirely separate entity in which the source locker resides. It seems incomparable to contrast the interior of another object to two things that are completely separate.
Why is it totally separate if it's a carport that is right next to the apartment?
Although
Everyone knows it is connected to the apartment, don't they?
it is not at all. It's a shared storage unit. And I would in fact refer you to Detective Barron's own witness, in which he cites, I had finished my search of the apartment and then I noticed the carport. He himself, the detective in this case, acknowledges there are two entirely different searches. And so with that in mind, it seems that there must be an entirely different search consent grant.
Isn't it a reasonable interpretation by the officer to believe that a carport is attached to the apartment? That people always park somewhere near their home?
I believe, although they may have been attached, I don't think they can be considered under the same search. I believe if he had considered it part of the same search, he would not have felt the need to go seek out consent.
You may continue.
In regards to a warrantless search, although I do believe that warrantless searches are an essential part of our justice system, we time and time again use the issue of probable cause. A certain threshold must be satisfied, it must be much higher. We've seen time and time again before defendant essentially protecting people's rights. And the fact that he was aware of the situation before he arrived at the apartment only reaffirmed that issue. You yourself cited that he should have gotten a warrant before approaching, and I do agree with that absolutely. When he spoke to Shem, he was aware of his consent. He needed to get consent from him again. With all of that in mind,
1 minute.
I respect yours and court. My apologies. Earlier we spoke about the key. You asked me if he had pulled the key out without a good warrant. I reviewed the case of U.S. v. Davis. In this case, there are two roommates, and a duffel bag belongs to one of them. The police in this case asked the other roommate whether they had permission to search the duffel bag. The roommate grants, and they grants consent, and they search the duffel bag. However, the court finds this consent is not valid. The property that is specifically owned under one roommate is his property, and needs consent from him. In this case, even if, like you said earlier, Gibbons had
30 seconds.
outside the apartment, consent would have needed to be explicitly granted from Shem, as this is his storage locker, and within the storage locker is his own box. With that being said, Your Honor, I respectfully support to agree with my motion and find this evidence to be admitted to trial. Thank you.
Thank you. Would you like to respond to that?
Yes, Your Honor. Can I proceed?
Yes.
Your Honor, we ask that when considering whether two areas are the same entity or separate, that you consider not just physical distance, but the legal status of these objects. In this case, the car storage shed and the apartment were a single entity. The car storage shed was part of the apartment. When Evan Shem rented apartment B, he received a complex of rooms and a storage shed. They cannot be bought, sold, or rented separately. And for these reasons, we ask that you consider them a single legal entity.
How do we know that?
Your Honor, the storage cabinet was clearly marked apartment B.
argument that the officer did not see the carport and the storage area until after the search of the apartment.
Your Honor, I would say that you just made your
Is that true?
The officer did not see the car storage shed until he had finished searching she searched what she believed was the entire apartment. Then, after seeing the car storage shed, she realized that she had not searched the entire apartment. This car storage shed was part of the apartment.
At that point, why should we not require the officers to go back and ask for consent to search something that's new and different?
Because, Your Honor, we do not consider this that new or different. It was part of the apartment that she had already received consent from Shem to search. Shem placed no limits on it. He did not say you can search all of the apartment except for the car storage shed. He said, have a look around. And that is what Detective Barron did. And after realizing that there was a part of the apartment that she had not searched, she went and she searched it. She already had consent to search that part of the apartment.
You may continue.
Thank you. Additionally, Your Honor, consent was given. Probable cause is necessary in warrantless searches where consent is not given, but as consent was given twice, first by Evan Shem and then by Charlie Gibbons, who objectively appeared to be a roommate. This warrantless search was very reasonable. Additionally, Your Honor, opposing counsel has brought up the case of Davis, but it is not applying this case because the car storage shed would be considered a common area of the apartment's occupants. It was clearly in the garage area, which is a common area, and the key that was necessary to open it was in the kitchen, another common area.
1 minute.
For these reasons, Your Honor, the prosecution again requests that you rule in favor of the prosecution in this pretrial motion and admit the evidence into court. Thank you.
Thank you. The attorneys on both sides have made excellent arguments. They clearly understand what the law is. There's always a balancing test that the court has to conduct in regards to certain procedure issues. In this case, my ruling is to deny the motion to suppress the evidence. It will be admissible at trial, and both teams have 30 seconds to consult with their coaches in regards to any procedural